Once again, we're on the record in case number 23-9757FY. And Ms. Claxton, did you have opportunity to review the allegations on the complaint, the nature of the offense, possible maximum penalties with Mr. Keener?
I did. We'll waive a formal reading. He'll be hiring counsel.
Mr. Keener, I'm going to remind you that you have the right to remain silent. Anything that you say, orally or in writing, can be used against you. You have the right to have an attorney present during any questioning. And if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. The right to a preliminary examination, in this case, it would be scheduled for July 21st at 11 a.m. with Judge Cooney. Also, on July 14th at 2 p.m., you will have a probable cause conference. Ms. Claxton, is there information that you would like me to know regarding bond?
Yes, thank you. We did have a chance to review the praxis. As scored, it would recommend release with conditions. I understand that's not being recommended due to the serious nature of the offenses. They are just allegations at this point. It's my understanding he has no criminal history. He does live in California. He would be working, and so he believes that he would be able to come back and travel back to court should the court allow his release. And so we would ask the court to consider a PR bond.
So, Mr. Keener, the court's concern is that there's also an address listed in Ohio, and then in California, and you find yourself here in Michigan. I believe that poses a risk as far as your ability to make sure that you make all of your court appearances. The nature of the offense and the allegations contained therein are significant. For those reasons, your bond will be $50,000 cash or surety. Conditions on the bond are that you'll have no contact in any manner whatsoever with. That means no phone calls, no messages through other people, no mail. You may not text message, nor through any social network have any contact with her, nor through any other person. You'll stay 500 yards or more away from her. You may not be at any address that she is or may be. You may not use or possess any weapons of any sort. You will have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. If you were to be released, you do not have the ability, I would not allow you to leave the state of Michigan. So you do not have court permission to leave the state of Michigan. You will need to find address in the state of Michigan so that you can be placed on a GPS tether supervised by community corrections. You would need a valid address where you're staying and a verifiable address where you would be staying. Again, community corrections would be providing the supervision on that GPS tether through the course of your case. The GPS tether would provide an exclusion zone, and again, that would be supervised by community corrections. Please make sure that you're in contact with an attorney as quickly as possible because those dates, the 14th and the 21st, is coming up very quickly. So you need to have your attorney on board so they can be able to assist you. I'm sorry?
I'm not alone. What's going on?
You need to pay attention to her.
I am. She said, I'm sorry because I wasn't sure if you were trying to say something. I don't know what's going on.
Okay. Well, so the last thing that we were going through was it's really important that you have an attorney on board as quickly as possible so that your attorney can be prepared for the probable cause conference on the 14th and the preliminary examination on the 21st. And then for right now, sir, you are all set.
Your Honor.
Sir.
Jesse Williams was just tried to zoom in, reference him, and he was going to try and log in the reports.
Oh, well, he's in the waiting room.
Thank you. Thank you.
Mr. Williams, what can I help you with?
I'm actually here for Mr. Keener. His family hired me, and I was actually zooming in with the jail to talk to him. So I came back to do his arraignment for him.
Well, we've already gone through the arraignment. I'm sorry. Mr.
It's
Keener
okay.
didn't know that you were retained. So the arraignment's been done. His preliminary examination will be
I
scheduled
tried
for
to.
for July 21st. His probable cause would be on July 14th. His bond is $50,000. It's a cash or surety bond. If he posts that bond, he is not allowed to leave the state of Michigan because he needs to be placed on a GPS tether supervised by community corrections. And obviously a no contact order is in place, which is in place whether you post the bond or not. You can't have contact with him even while you're incarcerated.
Can I address this?
Sure.
So a couple of things. He lives in California, and he needs to be able to leave the state. His family contacted me through a family lawyer out of Ohio, and they've gone as far, you know, that they're spending resources. He's going to appear at all court appearances. Was he charged with a felony?
Yes, sir.
What was it? The 10-year strangulation?
Well, it's a 10-year, but it's assault with intent to do great bodily harm, less than murder by strangulation. Yes, there are 2 counts of that.
So, I mean, that's a count that I'm familiar with. We see all the time. It's often overcharged. There's a presumption. And if the court's not going to go through the steps and make the proper record, there's a presumption it's a no cash bond. And that's the law.
Okay, so I have already gone through that, Mr. Williams. I'm sorry that you were late to this meeting, but I have already gone through that, and I would be happy to go through that again with you. There's another thing to consider, and that is the likelihood of conviction. And in this case, there were witnesses to the alleged offense. So, there's an evidence. Hold on, Mr. Williams. I'm all done, right? So there's an alleged address in Ohio, one in California, and he finds himself in Michigan. That worries the court as far as his ability to be contacted and the risk of failing to appear. The nature of the allegations in this case is such that I believe he needs to be supervised by community corrections on a GPS tether, and they cannot do that out of state. So the bond will remain as it is. We were welcome to argue that bond in front of the judge at the time of the probable cause or the preliminary examination.
You're making an improper record, though. The court is literally saying things that are not the proper procedure of bond. First of all,
Mr. Williams, I don't need to school me in what I need to do in court. So we're all set. Thank you.
No, hold on. I called the court this morning trying to figure out when to get arraigned. I wasn't informed. I want to make a record. I'm his attorney. I turned in an appearance. I am the attorney. So can I please make a record for my client? This is really extraordinary. Honestly, I contacted the court. So I'm asking the court to reconsider leaving the state and the GPS tether. I'm telling you, his family contacted me. I'm appearing. I've turned in an appearance. He clearly is not a flight risk. His family has spent resources to contact an attorney and hire that attorney to help him with his case. His family lives in Ohio. He is an aspiring actor who lives in California. And that's where he resides. The likelihood of conviction, this witness lives in Las Vegas, as far as I know. I don't even know how cooperating she is with the prosecution's case. So for the court to even make such an assumption is outstanding.
I'm not saying it was witnessed by the alleged victim.
Who cares? Without a victim, you don't have a case. So that's a silly road to go down.
It was witnessed by an independent person. Mr. Williams, once again, I have made my order. I've made my decision. I believe it's firmly grounded in the law. So
hold on. Can I please? I want to see a judge. I'm going to be in front of Judge Stepka shortly for my other case. Can we please go in front of the judge?
Ask the judge, you bet.
Will you just transfer them to him so I can see a judge on this?
I will not. You can ask the judge about that, Mr. Williams.
But all right. So you said it 50,000, 10%. What is the bond right now?
50,000 cash and surety.
This is a bizarre way to do things. There's people,
Mr. Williams, you say that every time, and it's just not true. It's
But
a
it is
very
true.
reasonable bond with the considerations that I have laid out on the record. It's a very reasonable bond, and for good reasons. So I'm all set. I need to see other people,
All right.
and this isn't going to get anywhere, so
right.
thank you very
all
much.
right, thanks. All right. Bye. Hey, I'm gonna see you in the jail, Mr. Keener. I'll be zooming in to the jail.
Like, what's going on?
We'll see you on the 5th, okay?
Yep. Thank you, Your Honor.
Your
All right,
Honor.
you're all set, sir. Yes?
Is it possible that we could have, Mr. Keener was just arraigned in front of the magistrate? I turned in an appearance this morning at 10 a.m. and somehow I just wasn't informed he was going to get arraigned today. I called the jail to try to get him arraigned and the court this morning. Is there any way we could address his bond? He lives in California. He's a professional actor. The magistrate gave him, he has no criminal history other than a marijuana in Ohio when he was 19. And he has to have a tether and he needs to go back to work. And the victim in this case lives in Las Vegas, Nevada. And he's just stuck in jail right now. And it's a 10-year offense. It's a felony, but the bond is really inappropriate for many reasons. But is there any way we could address his bond? Because he's been sitting there. He just got arraigned. And I wasn't able to. I got in there and the magistrate took some argument from me, but didn't really want to hear it and told me I could file a motion. But it's just an unfair process for him.
Also, I was alerted to this request that you would have, so I took a very quick look at the file. I did notice there's 2 10-year felonies, assault with intent to commit great bodily harm by way of strangulation. So those are serious felonies. They're assigned to Judge Cooney, actually, plus your client lives in California, no ties here, could be a flight risk. That's probably why the magistrate set the bond. I'm not going to disturb that. You can go ahead and file a motion, or Judge Cooney's out in Leelanau today. I suppose you could call out there and see if you could address it with him, but it's his case now, Jesse. I'm not going to disturb that.
All right. I will.
Okay.
All I was trying to do is get rid of the tether. It's a big bond to post. His family hired me. I'm just trying to get rid of the tether so he can go back to Mexico City. He has an acting job that starts on the 7th.
Okay. Well, I'm sure Judge Cooney will listen to that. Okay.
All right. I'll call out there. Thank you.
All right. Thank you.
Yep. Bye. Have a good holiday.
Bye-bye.